Greetings, everyone. I'm Joseph Richards, General Vice President for the Seventh Adventist Church in Canada, as well as General Counsel and the liaison for public affairs and religious liberty for the church in Canada. So I just wanted to give you a brief update on some of the things that are happening on the religious liberty front in Canada. I want to give you four developments that we're monitoring very closely. That's going to be the watchword for what I'm going to share with you today is monitoring. Highly vigilant on a lot of moving parts that are happening within the Canadian landscape. Number one, maybe you've heard of it, is Bill C9. It's a bill, proposed legislation that aims to strengthen Canada's hate speech laws. On its face, you look at it and read it and you say, well, hey, that's a legitimate goal. But there are still some really pressing concerns. Concerns about how broadly hate is defined, including by symbols and by subjective feelings. Concerns about a recently added provision in the bill, which says that religious and other statements on matters of public interest are not prohibited as long as they do not willfully promote hatred. So it's a bit of a circular reasoning. That's one of the concerns. What counts as a matter of public interest? That's another concern. Who decides when a sincerely held belief crosses the line into hatred? In Canada, we've historically let the courts balance these tensions on a case-by-case basis. For 50 years, our hate speech laws have been on the books. Rarely have there been prosecutions, but when there have been, judges have been able to distinguish between extreme forms of speech that are really targeting certain people groups and speech that is, in fact, that should, in fact, be protected. That's in part because there's a 40-year-old case from our Supreme Court that really outlines the contours of freedom of speech in conjunction with our hate laws, and that court case is still binding law, in my opinion. Regardless of what happens with Bill C9, it will still be binding law, at least for the foreseeable future, which means what's really the point of bringing forward this legislation of Bill C9? One would actually have that question and would really think, yeah, maybe this is not really needed. It's right now, it's in our upper chamber in the Senate, so we're monitoring it, we're watching to see if the text changes even more. It's very politically sensitive in Canada right now. The second issue that we're looking at is some developments out of Quebec with Bill 21. That's the secularism law. The law prohibits certain public employees like teachers and police officers from wearing visible religious symbols while on the job. So think about crosses, think about hijabs, turbans, kippas, and not to mention there's a version 2.0 of Bill 21 called Bill 9, which has just been passed at the beginning of this month in Quebec, and that deals with banning collective public prayers. So you can see how this aggressive secularist, agenda is really developing in the province of Quebec. We're monitoring to see what happens. The issue of Bill 21 is now before a Supreme Court. Arguments were heard on this at the end of last month. And so a decision will be coming forward in the next couple of months. And we're eagerly awaiting to see what actually, how the court deals with these issues. Because supporters argue, well, look, this promotes state neutrality, but critics, in particular from faith communities, argue that it's basically excluding people from public life, suppressing visible expressions of their beliefs. So we'll see what happens. The wrinkle is that Quebec invoked something called the notwithstanding clause. Section 33 of our Charter of Rights and Freedoms invoked that section when they passed the law. It's a unique feature of Canadian law that allows governments for a 5-year period and renewable 5-year period. It allows the government to to essentially override our charter rights. So this is of grave concern. There are still some arguments that could result in Bill 21 actually failing, not necessarily because of the charter, but some other principles of criminal law, even pre-charter. But we'll see how that develops and how the court rules on that. And the third issue that I want to bring to your attention is something that's coming out of the province of Saskatchewan. We're talking about the notwithstanding clause. Well, notwithstanding clause is being used by the government of Quebec and also by the government of Saskatchewan. It involves parental rights and gender identity in schools. And the province introduced a policy requiring parental notification and consent when a student under 16 seeks to change their name or pronouns at school. That policy was challenged in court, and guess what? Saskatchewan government said, we're going to use the notwithstanding clause to ensure that the law would remain in force regardless of charter challenges. So what we're seeing is that the notwithstanding clause is being used even preemptively by governments. Traditionally, governments waited. They allowed for the courts to make decisions on the constitutionality of a particular piece of legislation before then, as a last resort, using the notwithstanding clause. What we're seeing now in Canada is that governments are flexing their muscles a little bit and saying, we're going to do so preemptively. We're going to say, regardless of your rights, or we're kind of indifferent about which rights are affected. We're passing this piece of legislation. And that is setting some dangerous precedent, some dangerous democratic precedent in terms of how diverse democracies really function. We are being vigilant. We're making submissions. We're trying to ensure that our political representatives know exactly where the church stands on these types of issues. And we have to be careful, though, because sometimes there are issues that you may support, on a practical basis. You may support one issue, but guess what? If you support it here, you have to support it there. One case, it's actually being used, the notwithstanding clause is being used to suppress speech. In another case, it's being used to uphold common, decent values in terms of parental notification and parental consent. Fourth issue that I want to bring to your attention is the issue of MAiD. If you don't know what MAiD is, it's medical assistance in dying. So this is a very complicated issue. It hasn't really come up, at least not recently, in a grand legal challenge. There have been some challenges in the past that have ruled that the laws on the books are unconstitutional. And every time the government changes it, there's another challenge that says, oh, well, that is unconstitutional. And guess what? Because of that, our MAiD laws, medical assistance in dying laws in Canada, are some of the most expansive in the world, and they're due to become even more expansive. So while the laws in most provinces, with some exceptions, but most provinces include some protections for individual conscience, there's growing pressure on institutions, especially faith-based hospitals, long-term care homes. Think about hospices, where they're feeling like we're being forced to simply offer this medical assistance in dying as an option for residents. Many of these institutions were founded on deeply held religious convictions about the sanctity of life. Yet in some provinces, they're facing increasing expectations, indirect pressure to facilitate or allow MAiD on site, or to transfer patients in a way that conflicts with their beliefs. So a big tension is really bubbling up to the surface in Canada right now. Can a faith-based institution operate in accordance with its religious identity while participating in a publicly funded healthcare system? So this is unfolding. We're monitoring. We're seeing what will actually be decided on these matters. It still has some ways away. I believe there's a case right now in British Columbia on this issue, and it's still working its way up through the court system, and we'll see how that evolves. What we're noticing, if you take a couple steps back, is that and MAiD, this whole issue of medical assistants dying is showing us that even without the notwithstanding clause, even without referring to that specific exception within our Charter of Rights and Freedoms, there's a question that is being asked, whether there's room for religion in the public square. We're seeing how the practical space for religious conscience can be narrowed quietly, incrementally, and through administrative pressure, as well as through legislation and court pressure. But sometimes all it takes is administrative pressure, and MAiD really illustrates that. So what do these four developments tell us? Governments can give and governments can take away. Power is used for things that most of us can agree on. Legislative power can be used for public safety and education reform and parental rights. And these are issues that perhaps a majority of citizens in any community would say, yeah, we're kind of for that. Certainly in faith-based communities, you'd say, yeah, that's something we want. But that same power is being used to suppress and to limit speech and religion. Think about the case of Bill 21 and Bill 9 in Quebec. In other words, the same tool that protects one conviction today may suppress another tomorrow. These are big issues that Canada, from coast to coast to coast, that we are all wrestling with. And so the increasing use of measures such as the notwithstanding clause, it becomes a problem because it's a blunt instrument. And once it becomes normalized, as I said before, it's historically in Canada very rarely used, but now once it becomes normalized, it can just as easily be used in ways that restrict religious freedom, that limit expression, and that marginalize people of faith in the public square. We're already seeing different pressures through speech regulation, religious symbols in public life, and now even conscious in healthcare, each testing the room that exists, that remains for faith-based convictions. Let me end. I know I've been going on for some time, but let me end with a pastoral note here. As Seventh-day Adventist Christians, we're called to be faithful regardless of the legal environment that surrounds us. The developments I've described here earlier, I've talked about Bill 21, I've talked about Bill C9, the hate speech bill, I've talked about what's going on in Saskatchewan with respect to gender identity and parental rights, and I've talked about as well medical assistance in dying. What these developments remind us is that a religious liberty and religious freedom in Canada, indeed across the world, requires thoughtful attention. It requires careful stewardship, and at times a willingness to engage with the institutions that shape our laws, shape the policies that surround our laws. And that doesn't always mean speaking loudly. In Canada, we tend to be a bit more demure. We don't necessarily go and shout, and we're not bombastic and on all of these issues. It doesn't always mean that we have to speak loudly, but it does mean that we have to stay informed. What did I say at the beginning? We're monitoring, we're being vigilant, we're reaching out to our political representatives and making submissions. Have to stay informed, participating where we can, and supporting those who are working to preserve these freedoms. Because we know that even small acts of engagement can help ensure that religious freedom remains a lived reality for as long as possible, not just a legal or constitutional promise. I'm reminded of Acts chapter 5 and verse 29. The apostles declare, we must obey God rather than man. That is not a call to defiance for its own sake, but a reminder of where our ultimate allegiance lies. Laws may change, culture pressures may shift, but our commitment to truth and to conscience and to faithful witness must remain steady. And so we engage. We engage wisely, respectfully, and above all, prayerfully, seeking to preserve the freedoms that allow all people, and I put an emphasis on all people, to live according to their deeply held beliefs. Thank you for listening to this update. Continue to keep the church in Canada in your prayers and continue to keep all of Canadians in your prayers as we navigate the uncertain times ahead. May God be with you. Bye for now.